Good evening, my name is Karen Harding and I am an Admiralty lawyer from Auckland, New Zealand. I'm here tonight just to brief you on what's going on in relation to an employment law case involving Indonesian foreign fishermen against the Sajo Oyang Corporation, which is an Indonesian multi-million dollar fishing corporation that had vessels in New Zealand, and the allegations are that that fishing company exploited the foreign workers who are here in New Zealand on those vessels on New Zealand work permits by not paying them their minimum wages and committing various human rights abuses on them, and also require them to work in abject conditions. We are taking a test case through to the Employment Court, seeking some of the biggest extensions, or the biggest extensions in New Zealand history, for the cases to be able to proceed in the Employment Court in relation to breaches of personal grievances and breaches of the Employment Relations Act, and I would like to just brief you on that at the moment. So I'm just going to go through a summary of the applications that we have that will be going through to a hearing on the 30th of October in the Christchurch Employment Court. And the case is EMPC 6/2017. It did start in the Employment Relations Authority and was transferred to the Employment Court. However, on the transfer, that meant that none of the files actually get moved from the ERA to the Employment Court, and a year's worth of litigation has been lost in terms of paperwork, documents and affidavits filed, and they will have to be refiled again. We're looking at having to refile affidavits by the 10th of May 2017 and then further submissions thereon. So just going through our notice, so we're taking notice that on the 30th of October 2017 we will be applying for the following things. One is a transfer of the proceedings out of Christchurch to the Auckland Employment Court. So far that transfer hasn't been granted. There is some law that says under section 24 (2) of the Employment Relations Act that you can apply for a transfer to another court. There's no successful case ever granted in New Zealand employment law where the transfer has been granted. So it's a law that's supposed to allow for flexibility, but in practice there seems to be no flexibility. In relation to the determinations that we're seeking, we are looking to start with that the court will need to determine the status of the plaintiffs, that's the fisherman's relationship to the defendant, the Sajo Oyang Corporation, their employer. The first thing that the court will need to determine is, one, was the defendant the employer of the plaintiffs, and were the plaintiffs their employees? We say that the plaintiffs were the employees because they come within the definition of Section 6 of the Employment Relations Act 2000, and that the defendant was not permitted to contract out of this employment relationship with the plaintiffs. The plaintiff's status was that of a foreign fisherman employed on New Zealand work permits to work exclusively on the defendant's vessels, the Oyang vessels, and in particular my clients were working on Oyang 70 and Oyang 77. And the employment relationship was subject to the following legislation and procedures that we say, which is the Employment Relations Act 2000, the Minimum Wages Act 1983, the Wages Protection Act 1983, and the Holidays Act 2003, and Section 103 (5) of the Fisheries Act 1996, and we also submit that it's subject to Section 2 section of the Code of Conduct for Foreign Fishing Crew 2006, which is known as a 2006 COP. The court will need to determine what the pay entitlements were of the plaintiffs, how to calculate those entitlements, what was paid, and the amount of any short pay wage arrears. The court will need to determine the following questions. 1. Were the plaintiffs entitled to be paid the minimum wage and the hourly rate for every hour of work performed? B. Were the plaintiffs entitled to the extra top-up hourly rates that applied during the material times per hour for the foreign fishing crew pursuant to the 2006 Code of Conduct for Foreign Fishing Crew? Thirdly, were the plaintiffs entitled to be paid for on-call work and for sleepovers? And fourthly, were the plaintiffs entitled to holiday pay and statutory holiday pay under the Holidays Act 2003? The plaintiffs seek a determination from the court that they were entitled, as employees of the defendant, to be covered by Section 6 of the Minimum Wages Act 1983, given that they were employed to work in New Zealand and were on New Zealand work permits. 1. The plaintiffs seek a determination that they were entitled to be paid pursuant to the Minimum Wages Act 1983 for every hour they worked. B. The plaintiff seek a determination that they were entitled to be paid for sleepovers. C. The plaintiff seek a determination that the sleepover periods on the vessels involved work pursuant to Section 6 of the Minimum Wages Act 1983. D. The plaintiff seek a determination that they were and are entitled to be paid for every hour they worked, including the sleepovers, on a 24-hour, 7-day-a-week basis pursuant to the applicable minimum wage hourly rates that applied during the material times that their plaintiffs were employed with the defendant on the vessels. E. The plaintiff seek a determination that, being quotation marks on call, where there were no set shifts of reasonable hours as sleep and rest periods were interrupted to go back to work to perform duties. Accordingly, we submit that this fits within the determination of a sleepover and that it was work subject to Section 6 of the Minimum Wages Act 1983. F. The plaintiffs also seek determination that they are entitled to be paid the extra top-up hourly rate per hour in addition to the minimum hourly rate under the Minimum Wages Act 1983 that was payable to foreign fishermen for every hour worked, including sleepovers for the material time periods that they were employed by the defendant on the Oyang vessels under the 2006 Code of Conduct for Foreign Fishing Crew. And G. The plaintiffs seek a determination for an order that they are granted an extension under Section 219 of the Employment Relations Act 2000 in respect of the causes of action and short pay wage arrears claims, including the holiday pay claims that arose outside the applicable limitation periods. The plaintiffs seek a determination that they were entitled to be paid for sleepovers on a 24-hour, 7-day-a-week basis over the entire length of each employment agreement, their contract, with the following entitlements. 1. The minimum wages rates per hour according to the Minimum Wages Act 1983. B. The applicable top-up rate under the 2006 Code of Conduct for Foreign Fishing Crew, which gives them an extra couple of dollars per hour. C. Holiday pay entitlements, including statutory holiday pays pursuant to the Statutory Act, which is the Holidays Act 2003, and other holiday pay entitlements under the Holidays Act 2003. 4. Sleepovers. The plaintiffs seek a determination that the plaintiffs were on call 24 hours a day, 7 days a week while they were employed on the Oyang vessels during the length of their employment with the defendant. They seek a determination that they were working over those sleep hour periods. The court will need to address the question that if the employees were working during the sleepovers, how should their remuneration be calculated? We seek the determination that the wage should be calculated, the minimum hourly rate per hour, plus the extra top-up rate per hour under the 2006 Code of Conduct for Foreign Fishing Crew, and if they occurred on a public holiday or a statutory holiday, that they also get the public holiday rates per hour. In relation to holiday pay, the court will need to address the issue of whether the plaintiffs were entitled to holiday pay and to statutory holiday pay. The plaintiffs seek a determination that they are entitled to holiday pay and statutory holiday pay pursuant to the Holidays Act 2003. The plaintiffs seek a determination that they are entitled to have annual holidays pursuant to the Holidays Act 2003. The plaintiffs apply for an extension to the lodging of all claims and seek a determination that they can apply for extensions under Section 219 of the Employment Relations Act 2000 to lodge a claim for short pay wage arrears, including holiday pay arrears and statutory holiday pay arrears and sleepover holiday pay arrears. Section 6. Section 12, capital A of the Wages Protection Act 1983, determinations sought. The court will need to determine if Section 12A of the Wages Protection Act 1983 was breached. The court will need to determine if cash premium fees were obtained from the plaintiffs in return for employment with the defendant on its vessels. The plaintiffs seek a determination that cash fees were obtained from them in breach of Section 12 capital A of the Wages Protection Act 1983. The court will need to determine if security in the form of property and wages that were withheld from them were obtained and taken from the plaintiffs as part of their employment relationship. The plaintiffs seek a determination that the defendant breached Section 12 capital A of the Wages Protection Act 1983 by it and its Indonesian manning agents, charging the plaintiffs' employees cash fees to get a job with the defendant on the Oyang vessels, which is prohibited under Section 12 capital A, and by the imposing of security conditions and signing their employment agreement contracts in Indonesia prior to flying out to join the vessel in New Zealand. where the wages were withheld as a precondition to obtaining the employment. We say that's a breach of Section 12A of the Wages Protection Act 1983. The plaintiffs further seek a declaration that the defendant breached the International Labour Convention 97 (1) Migration for Employment, which New Zealand has ratified, which requires that migrant workers have access to healthcare and be treated fairly in respect to wages and conditions. We say this was breached. Section 4. Forced labour issues on the defendant's vessels. The plaintiffs seek a determination that the plaintiffs became forced labour after they commenced work on the Oyang vessels, and that this was breached by the defendant of the Wages Protection Act 1983 and the 2006 Code of Conduct for Foreign Fishing Crew and other applicable legislation and ratified international obligations. The plaintiffs seek a determination that they became forced labour due to the following combination of factors that arose in this employment relationship. A. Deception was involved in obtaining the plaintiff's consent to work on the Oyang vessels. And B. The plaintiffs had to live and work in abject working and living conditions on the Oyang vessels. C. The plaintiffs were forced to work overtime, which was not appropriately remunerated at the minimum entitlement rates. D. The plaintiffs received bad treatment on the vessels from their employer and their employer's representatives. E. There was abuse of Indonesian crew members on the vessels that created a climate of fear and intimidation and disadvantage on the vessel. F. There were security conditions imposed on the plaintiffs to obtain employment and to guarantee that they would perform their contract, which caused the plaintiffs to work under a menace of a financial penalty. G. The plaintiffs, once on board the Oyang vessels, then worked under this menace of a financial penalty whilst employed by the defendant, the Sajo Oyang Corporation, in abject conditions, and were not free to withdraw their services without financial penalties being imposed on them by their employer or their employer's representatives and agents. H. There was no proper complaints process on the vessel. And I. The plaintiffs were not paid their minimum wage entitlements. We say this amounted to forced labour, and we seek a declaration and determination from the court that this is so. Section 8. The court will need to determine jurisdictional issues. The court will need to address the issues raised by the defendant about whether it has jurisdiction to hear the claims and applications lodged and filed by the plaintiffs in the Employment Court. The plaintiffs seek a determination that the Employment Court has the jurisdiction to hear these proceedings and has the jurisdiction over this employment relationship problem, matters, complaints and personal grievances that arise out of Section 103 of the Fisheries Act 1996 and the other applicable legislation, including the 2006 Code of Conduct for Foreign Fishing Crew, as it affects this employment relationship between the defendant employer, the Sajo Oyang Corporation, and the Indonesian foreign crew members who are on the work permits here in New Zealand on their vessels as their employees. 3. The plaintiffs seek a determination that the defendant is required to submit to this court's jurisdiction. They are denying that as a foreign company that they don't have to submit to the New Zealand courts. We ask the court to determine that that's a nonsense and that they have no basis to object to the court's jurisdiction and they must submit to it. The plaintiffs seek a determination that the court does have jurisdiction to hear all their claims and all their applications. A. The plaintiffs seek a determination that the court has jurisdiction to hear matters with respect of the plaintiffs that fall outside the Wages Protection Act 1983 and the Minimum Wage Act 1983. This is because I'm facing an argument from the Sajo Oyang Corporation lawyers that the court doesn't have jurisdiction outside the Minimum Wages Act and the Wages Protection Act. B. The plaintiffs seek a determination that the court has jurisdiction to hear their wages claim. C. The plaintiffs seek a determination that the court has jurisdiction to hear holiday pay claims under the Holidays Act 2003 by foreign fishermen employed to work on vessels in New Zealand on work permits, because the Sajo Oyang Corporation lawyers deny that they have jurisdiction to deal with holiday pay issues and deny that foreign fishermen on work permits are entitled to holiday pay. D. The plaintiffs seek determination from the court that it has jurisdiction to hear claims from the foreign fishing crew alleging breaches of the conditions and terms of the 2006 Code of Conduct for Foreign Fishing Crew, including the failures to pay the wage top-up entitlements to foreign fishermen under that 2006 Code of Conduct and personal grievances and other matters. E. The plaintiffs seek a determination that the court has jurisdiction to hear personal grievances claims lodged by the foreign fishermen against their employers who performed work on vessels in New Zealand on work permits, and F, the plaintiffs seek a declaration and a determination that fishers as a class of occupation and profession, including foreign fishermen, are not excluded from the right to make a personal grievance claim in the Employment Relations Authority and the Employment Court of New Zealand, where they have worked here on New Zealand work permits. The plaintiffs seek a determination from the court that the court has jurisdiction to hear their personal grievances. The plaintiffs seek a determination from the court that they raised their personal grievances when they were on the Oyang vessels during the period of the 90 days within which the action alleged that amounted to a personal grievance occurred or came to the notice of the employer and or to the employer's representative pursuant to section 104 round brackets 1 and round brackets 2 of the Employment Relations Act 2000. If in the alternative it is determined by the court that they did not make a personal grievance claim sufficiently clearly known to the employer and or the employer's representative within the 90 days of the action alleged that amounted to a personal grievance, then the plaintiffs seek leave to apply for an extension to raise that personal grievance after the 90-day period on the basis that there are exceptional circumstances pursuant to section 115 round brackets A, comma round brackets B, comma round brackets C and round brackets D of the Employment Relations Act 2000. And they apply for a further extension order under section 219 of the Employment Relations Act 2000 for the court to hear their claims. I note that in the case of Reba versus Billac Services Limited 2014 NZERA Auckland 250 at paragraph 22, it was held that verbally raising a grievance was held to be sufficient. Next section. In addition, the plaintiffs seek the court to find that there are other special circumstances that warrant the discretion of an extension order being granted. These are as follows. A. The plaintiffs were at sea for periods of up to 2 years on vessels, and they were unable to get legal advice during that time or to commence proceedings. B. The plaintiffs do not speak English and have communication barriers for access to justice and for the delivery of legal services to them. The plaintiffs were not advised of their rights under the New Zealand law by their employer and or by their employer's representatives. D. There was no proper complaints process on the vessels for the plaintiffs to gauge in, and the employer and its representatives ignored the plaintiffs' complaints, which the plaintiffs claim amounts to advice to the employer that they had made a personal grievance. The employees raised these issues with the employer at the time on the vessel and also immediately on return to Indonesia with the representatives of the employer when they disembarked from their time here in New Zealand. The plaintiffs seek a determination that the Indonesian manning agents of the defendant who dealt with the plaintiffs were the representatives of the employer for the purposes of these proceedings. E. The plaintiffs were afraid of their employer due to the abuse going on the vessel and also because of the security conditions imposed on them by the employer and by the employer's representatives in Indonesia, being the Indonesian manning agents. H. The plaintiff's employment contract did not explain and did not contain an explanation concerning the resolution of employment relationship problems as was required under section 65 of the Employment Relations Act 2000, and it breached section 65 round brackets section 65 round brackets 2 round brackets A round brackets little IV comma round brackets little v close brackets round brackets little vi and section 65 round brackets B round brackets little I and round brackets little double I of the Employment Relations Act 2000, amongst other breaches of the provisions of the applicable legislation. In respect of two specific plaintiffs, being my number 20 and my number 3, who were unjustifiably terminated in a humiliating way and then financially punished for complaining, which the employer did we say unjustifiably, the plaintiffs raised these personal grievances, we say, with the employer and or the employer's representatives at the time. And we say that there are, in addition, the following special circumstances under Section 115, round brackets C, of the Employment Relations Act 2000, because the employer failed to comply with Section 120, round brackets 1, of the Employment Relations Act 2000 by failing to give them a statement of reasons for dismissal. In addition, the employer is disputing that employees can make and lodge any personal grievances with the Employment Relations Authority and the Employment Court. And there are other unique factors particular to these plaintiffs in relation to their particular personal circumstances that the plaintiffs found themselves in when they returned to Indonesia. They experienced impoverishment, extreme financial hardship due to not being paid their full wage entitlement, and they had extreme difficulty in engaging counsel to assist them due to these special circumstances. Section 9, limitation periods. The court will need to determine issues relating to limitation time periods raised by the defendant, being the lawyers of the Sajo Oyang Corporation. A. The court will need to determine when the 6-year limitation period started and ended under Section 142 of the Employment Relations Act 2000 for each of the plaintiffs in respect of each wage arrears and holiday pay and statutory holiday pay arrears claims. Collectively, I refer to them as short pay wage arrears claims. B. The court will need to determine when the 3-year limitation period started and ended under Section 114 of the Employment Relations Act 2000 for each of the plaintiffs in respect of the plaintiff's claims for personal grievances. And C. The court will need to determine what other limitation periods applied, started and ended under any other applicable legislation and regulations that may be found to apply to this employment relationship. Section 10. Extension applications and jurisdictional issues. The court will need to determine if the court has jurisdiction to grant the plaintiff's extensions under Section 219 of the Employment Relations Act 2000 for lodging claims and filing applications that include A. Applications for extensions for lodging and filing claims for minimum wage entitlements and arrears. B. Applications for extensions for lodging and filing sleepover wage claims arrears. C. Applications for extensions for lodging and filing claims for extra top-up hourly rate wage entitlements per hour worked under the Code of Conduct for Foreign Fishing Crew 2006. D. Applications for extensions for lodging and filing claims for holiday pay and statutory holiday pay entitlements. E. Applications for extensions for claims for any bonus entitlements that were paid short. F. Applications for extensions for the lodging of personal grievance claims. And G. Applications for extension for raising any personal grievances outside the 90-day period and claims of exceptional circumstances. The plaintiffs seek a determination that the court has the jurisdiction and discretionary power to grant all extension applications applied for and referred to herein. The plaintiffs seek an order granting all extensions as may be required for all claims, causes of actions and personal grievances claimed, so that they can be heard and determined in this court in the interests of justice. Section 11. Calculating the wages. The court needs to address the issue of how the plaintiff's wages should be calculated. The court needs to determine what the plaintiffs have been paid. The court needs to determine whether the wages, including any holiday pay, entitlements have met the minimum requirements under the Minimum Wages Act, the 2006 Code of Conduct for Foreign Fishing Crew and the Holidays Act 2003. The court will also need to determine if there are any unauthorised deductions taken from the plaintiff's wage entitlements, if there were deductions made, to take the plaintiff's wages below the minimum applicable wage for the applicable time periods. Section 12. Section 132 Application. If the defendant and as the plaintiff's employer has failed to keep or fails to provide the wage and time records in respect of the plaintiffs, we seek a determination that the court accepts under Section 132 of the Employment Relations Act 2000 the short pay wage claims made by the plaintiffs and the evidence of the plaintiffs as to what wages were paid to them for the hours, days and times worked by the plaintiffs. Section 13. We also make a disclosure application. The plaintiffs apply for disclosure from the defendants. So far, we've never received any disclosure from the defendants' lawyers. We seek the wage and time records for the plaintiffs, pay slips, banking records, printouts of bank statements, and transfers to show what payments were made to the nominated bank accounts of the plaintiffs and on what dates. The plaintiffs can supply the nominated bank accounts if needed for their details. Other relevant documents, including records about the employment relationship between the defendant and the plaintiffs and their employment terms and conditions. E. Records about the defendant's relationship and its Indonesian manning agents and the plaintiffs with them. Immigration New Zealand records of the authority in principle to recruit foreign fishing crew, and work permits applied for and other correspondence and applications relating to the employment of foreign crew on their vessels during the material times and about the plaintiffs. A copy of the guarantee, other documents as requested in an itemised list, other relevant records, and any other documents that may be requested by counsel. Where the defendant failed to keep or produce those records, we seek to make an application under Section 132 of the Employment Relations Act 2000. That means that if we can approve the case and they cannot disprove it, that our claim's approved. That is an overall summary here in this folder of the outline of the determinations that we're seeking. So that document there was a 14-page one in Section 1 of the summary of the applications, determinations and declarations that we are seeking in respect of this court to deal with these matters. Hope you found that helpful.